What is a perinatal injury? Well, essentially, it is an injury sustained by a baby during the birthing process. The birth process usually means the delivery of the child, often because there has been a failure to do a caesarean section or a ventouse procedure, which would have got the child out earlier. Sometimes, though, a perinatal injury may mean an injury sustained in the womb, either as a result of medical mismanagement or as a result of some independent problem, such as a road accident or a fall of the mother. Who do you go to for that? Well, first of all, you are going to need, in almost any case like this, a midwifery expert. That expert will look at the medical notes. They will look at a witness statement from usually the parents, possibly other people who attended, such as family members who were present at the birth. Those witness statements and medical notes, in effect, form the basis of the claimant's case. It is unlikely that the claimant is going to be a witness at this stage because the claimant is, first of all, probably a small child, and secondly, may have cognitive disabilities in any event. In terms of causation, whether you've got a cerebral palsy claim or a hypoglycemic claim, you will need a neonatologist. Neonatologists specialize in the care of newborn children, and your neonatologist will consider whether the presentation of the child in the immediate aftermath of birth is consistent with a perinatal injury. That is to say, whether or not, for example, there has been undue delay causing oxygen deprivation or similar. It is also worth saying that in the specific case of children with possible hypoglycemia, the neonatologist will deal not just with causation, but also with whether there was competent care in the postpartum period by the doctors and nurses looking after the child. You may also need to go back to the midwife for a view as to whether or not the midwifery care was competent if there is a hypoglycemic issue.